Oftentimes in our drug cases, they involve some type of surveillance, and that surveillance either being visual or audio surveillance. And that's even beyond cases that have Title III wiretaps. We were handling a case where an informant had lured our client into an establishment and the room had been wired for sound by the DEA. The DEA officers were in literally the next room listening. What occurred in that case is our client went in to conduct a transaction. The transaction took place. Part of the transaction was for the informant to introduce the undercover agent to our client to basically ultimately effectuate the arrest, but to elicit additional information out of him. At one point in time, in the most critical point in the transaction, the informant left the room and the agent left the room. Our client was in the room but was placing calls relative to the transaction. What ultimately we raised the issue that this turned into an illegal wiretap, because in Colorado, one party is allowed to tape without the consent of another party a transaction. But by the officer leaving the room, leaving our client and taping our client in a conversation with another party who was not in the room, that created in effect an illegal wiretap, or at least arguably. And the point being, from our perspective, we raised at the preliminary hearing the fact when the police officer was testifying, I stood up and indicated to the court, Your Honor, I think that the agent may be incriminating himself by being involved in an illegal wiretap. There was somewhat amazement by the court. I don't think the court followed what we were talking about until we explained the details of that. And at that point, I asked the court to read the agent his criminal rights, his Miranda rights. To say the least, that got the attention of all parties. That resulted in our ultimately being able to resolve the case.